Ms. Ostrom, are you there?
I'm here, Your Honor.
And Steck, you there as well?
Yes.
Excellent. We are on the record in 18cv27149, Byers versus Dyke. Have Ms. Ostrom on the phone on behalf of plaintiff, Mr. Dyke on the phone on behalf of himself. Set for hearing in that case. Got a couple of, or a few motions I think we can resolve this morning, and then we can talk about where we need to go from here. The first I have is Mr. Dyke's motion for a mistrial that was filed July 12th. I've reviewed that as well as the response, I'll call it, that was submitted as well. Mr. Dyke, do you have anything else you want to add to that motion?
I didn't think that at a status conference motions would be litigated, so we weren't prepared to address that today.
Right, but did you have anything else you wanted to add?
We're mostly doing that for the record. We feel that the adjudication was not lawful and what it should have been.
Ms. Ostrom, anything you'd like to add with regard to that motion?
Generally, just resting upon our pleadings that it was untimely, and because it wasn't a trial, it's not appropriate or warranted.
I'm sorry, I didn't get that comment.
She indicated they were going to rely on what they filed, but generally that it was untimely and improper, more or less. Is that a fair summary, Ms. Ostrom?
Yes, Your Honor.
Okay.
Yeah, we consulted with one attorney, and they said you file a notice of appeal as soon as the motion for partial summary of judgment is granted. Another attorney says you wait until final judgments are made. So we're kind of tired of hiring attorneys to figure out exactly how to position ourselves in the event that we feel the heirs of Lewis Nichols should appeal this.
Fair enough. So with regard to the motion to mistrial, that I'm going to deny. It's really not proper at this time, given that we haven't commenced a trial. There's not a trial to have had an error occur at. What it really looked to me like was that it was a motion to reconsider the motion for summary judgment, which I'm also not going to do. Frankly, a little confused, given that defendants had indicated in the documents they filed in response to that motion that they were choosing not to dispute Claim 1 for quiet title by adverse possession, which was all that was resolved by the summary judgment. So I'm going to deny that motion.
Okay, Your Honor, can I ask a question?
Go ahead.
It's unknown to us to what extent their motion for partial summary judgment is accepted. Is it accepted by the court in its entirety, or just the extreme limitation of Claim 1?
To be clear, and I think the documents bear this out, the summary judgment was granted as to Claim 1, which means only the relief that was requested in Claim 1.
Okay, Your Honor, you didn't rule on any of our objections to that motion, so we're left wondering how to deal with all the extra stuff that goes beyond Claim 1.
I don't think we need to...
Your Honor,
go ahead.
I'd just like to restate our position, which is that we sought partial summary judgment solely for Claim 1. And it was our understanding that that was what was adjudicated.
And my belief is that was what we did.
Your Honor, their motion contains misrepresentation of the concept of actual possession. They are making statements were made that go beyond the scope of Claim 1 regarding actual possession.
And I think the confusion, Mr. Dyke, is that what was granted was the relief they requested under Claim 1 in the, I think it's an amended complaint at this point.
Yes.
If they had thrown into a declaration or even some part of the motion that unicorns were a creature that existed in reality, the fact that I granted Claim 1 doesn't mean that that's a fact. So to the extent they allege things in that document that you disagree with, which you're entitled to do, doesn't mean that those are not issues that could be litigated with regard to Claim 2 and 3, to the extent that they're not directly related to the elements that were necessary for Claim 1. So that's my view of it. I think that addresses your concern. I could be wrong. Obviously, I can't read your mind, but based on what you've pled and what I understand your argument to be today, I think that addresses your concern.
Well, Your Honor, we feel we didn't have a full opportunity to object to fees and disbursements and costs. To us, that's very ambiguous. Which parties are targeted for such things, and do we have an opportunity later to object to those things?
To the extent that fees and costs were awarded, there is a process to go through for that, and you would have an opportunity to object with regards to amounts or whether it's appropriate, so that we can address. That's still pending. So I want to move on to, you filed titled an opposition to documents received from plaintiff's attorney on 7/12, and it looked to me, again, like really what that was requesting, that we revisit the motion for summary judgment based on your concerns about these, at least what you view as extraneous facts that you disagree with. I'm going to the extent that that is a motion, and it's not clear to me that it is, I'm going to deny that one. Then you also filed a reply to documents filed by plaintiff's attorney on 7/29.
It might have been the order for the motion.
The objection to either the order or the judgment or both. Again, both of those appeared to me to be essentially requests I review the motion for summary judgment. I didn't see any direct complaint about what was included in the order or the judgment, and I have signed those, and I'm going to stick with that. That gets me to a motion to compel...
Wait, Your Honor, can I clarify?
Please.
To the extent that this document is a motion, can I just have you on the record saying whether or not you affirm or deny it?
I'm going to deny it to the extent that it is a motion. It looked to me like it was intended to be objections to the proposed judgment and order. And I've signed both of those. So to the extent it was objections, they were overruled. To the extent it was a motion, it's denied. Which then gets me to the motion to compel request for production set 11. That request requests documents and things evidencing methods used by plaintiff for calculating or determining damages for Claim 2 and 3 of the lawsuit. Ms. Ostrom, I understand you objected to that request. If I'm reading your paperwork correctly, what's the basis of the objection, just to make sure I fully understand it?
The basis of our objection is that his request seeks production of expert opinion and looks for work product and or attorney-client privileged information.
I want to make sure I understand. Really, the objection is because he is seeking documents related to the method of calculating as opposed to documents which simply establish damage. Is that accurate?
Yes, Your Honor.
And maybe that's not as clear as I could be either. I'm thinking, and I know it really doesn't apply in this case, or at least I don't believe that it does, that there was some physical damage to the property which your client had repaired. Should he have invoices or receipts, that's not what you're objecting to. You would be objecting to documents that would demonstrate the methodology or your thinking of calculating damages. Accurate?
Yes, Your Honor.
Okay.
Yes.
Mr. Dyke, why do you believe that's an invalid objection?
Your Honor, they're claiming $20,000. It's under $20,000 of damages, and they've yet to give any explanation or any rationale for their damages, and it only appears like they randomly are pulling a figure out of a hat. I've labored for months now trying to get them to show damages, and we all came to the point where we realized there are no documents in support of damages, and now I'm trying to figure out where their figures came from.
Okay. So I understand what you're trying to do, and I can certainly understand why you want to do it. but I don't believe that this request is permissible given what we already know or have been told that there aren't any documents that actually demonstrate the amount of damages, like a bill or an invoice, something like that. Prying into the attorney's mind, or frankly even the client who's in consultation with the attorney, is not something you can discover. If plaintiff had sat down, I suppose, before consulting an attorney and had penciled out their damages in some detail, that might be a discoverable document, but it doesn't sound like that document exists. There may be a way for you to get at what you're looking for, but this a request for discovery probably isn't it. So I'm going to deny that motion to compel.
So Your Honor, to review what was said, Rosa is saying it's a matter of expert opinion. The damages are.
Could be.
If it was a matter of expert opinion, don't you think that expert would have given some document? Or
that may be. Let's assume, Mr. Dyke, for a moment, that there is an expert, that expert has delivered a report to Ms. Ostrom.
Okay, so I can attempt to discover that.
No. That's what I was just going to say. Expert discovery in Oregon is kind of a unique animal among litigation in the states. It's essentially by ambush, for good or for bad. You generally don't get that information until you're sitting there in the courtroom. So, Your Honor,
you're saying I can attempt to discover documentation of judgment, or not judgment, damages, and if those documents are a matter of expert opinion, they don't have to provide them? They can surprise me with them at trial?
If it's an expert report that you're seeking, yes, that's true.
What's the difference if a document is a document?
There's a significant difference under Oregon law, and unfortunately that's the way it is. There is, to be fair, there's a pretty wide disagreement about whether or not that's the appropriate way to go, but that is the way we go in Oregon at this point.
Sounds like something to resolve a deposition.
And that may be an option. So I'm going to deny that motion to compel. That moves us to your second one we need to address today, which deals with the request for production set 6, which was for requests of documents and things evidencing possession of the real property in Wasco County, commonly known as 326 West 21st Street, by the defendant during 2018. Ms. Ostrom, it looked like you had objected to that, 1, as overbroad, and 2, as privilege. Have you provided any documents in response to that request, despite the objections?
We have not. We did provide a copy, the true and correct copy of the lease, which was requested in several other requests for production. And we believe that defendant Mr. Dyke has one of his more recent requests for production, which I want to say...
utility bills.
It was, yeah, his request for production set 28, which we just filed a response to. He requested utility bills. We are in the process of requesting those. And beyond those two things, it's unclear what he's asking for in this request because it's so broad.
To clarify, evidence of actual possession.
And, Your Honor, our position is evidence of actual possession is so immensely broad. It's like saying we want every piece of mail that's gone to this house, or we want...
A sample of mail might work fine.
But, Your Honor, we believe that this is unduly broad and overly and not reasonably particularized to lead to relevant evidence that will be useful in this case.
So, Mr. Dyke, I think what the issue is a couple of things. One, essentially, this doesn't specify any particular category of documents or evidence, and I'm just trying to think what might provide evidence of possession during a particular time frame. I suppose paperwork with that address on it might. I'm not sure that it necessarily does. For example, a landlord could be
paying the bills for the renter,
not living on the property, and the parties, I understand, they have some difference of opinion as to whether or not that arrangement is possession, and we can get to that. It looks like you've already requested utility bills, which is going to cover that issue. Are there some other documents you believe would exist if Mr. Byers was in possession that would be covered by this request?
I only find documents contrary to that, such as the Construction Contractors Board documents and the Oregon Assumed Business Name documents. They're all contrary to his strange claims of possession.
And, Your Honor, we believe that reflects our difference in understanding of what possession is.
Your Honor,
I recognize that, certainly acknowledge that, Ms. Ostrom, that there's a basic difference of opinion as to what possession is, which may also complicate this particular request.
I think I said actual possession in my discovery request. That should be pretty straightforward.
Documents and things evidencing possession.
Yeah,
I'm sorry, I guess I could refile it.
That's what I have, is evidencing possession, and honestly I'm not sure there's a difference between actual possession and possession in terms of what would be relevant for this case. I think, Mr. Dyke, if I understand what you're really trying to get at, it's documents that would evidence Mr. Byers was living on the property.
Yes, sir. Documents and things, evidence in residence. I guess that would be more precise.
Ms. Ostrom, is there any dispute that Mr. Byers didn't reside on the property during 2018?
I believe he resided on the property during part of 2018, but then began renting it.
Okay. So there may be some evidence that he did reside on the property during 2018.
Your Honor, I think she's mistaken. It's really 2017 when the rents commenced. They were well into their rental in 2018.
I don't have the lease in front of me, but there's no dispute that he rented it to another party.
And that's fine. I guess what I'm trying to do is help speed the discovery process along so that we can get this set for something that might actually resolve it for everyone. So I'm going to deny the motion to compel at this point in time, but what I would like, given the clarifications we've dealt with today, I would like, Ms. Ostrom, for you to indicate, and you can do it at some point later in writing, that's perfectly fine. I don't expect you to have all of this at the tip of your tongue or on top of your brain, however you want to look at it. But let Mr. Dyke... We're getting some interference there from somewhere.
I'm hearing that too.
Mr. Dyke?
What you just said?
Yeah, what I was going to say is I'd like you to let Mr. Dyke know, or provide the documents if they exist, that there are no documents that would indicate Mr. Byers was residing on the property during 2018, or provide those documents that he might have in his possession. So that instead of going through another request that's going to filter that down, we can just get those documents to him essentially in response to this request as clarified today.
Understood, Your Honor.
And my suspicion, just based on my quick review of the file last night, was that there probably aren't any, because I don't think he did reside there, but I could be completely wrong too. Not like we've sat through a full trial and have all the evidence.
Can I ask a clarifying question?
Sure.
When you're talking about documents showing that he lives there, that could encompass a very, very large world of documents.
Right,
We've been talking a little bit about what specific documents might look like. Would you be willing to kind of narrow that universe just so that we can be specific and not have to turn over, every
thousands of documents.
Yeah.
I think it would make sense if he has utility bills, some sort of mail that has his address at that address during whatever time period that's stretched out over 2018. That would certainly be helpful, and that may be covered under the utility bills request anyway. I'm trying to think what else someone might have that would prove they were actually in residence, as opposed to just paying bills or receiving mail at that address, and I'm not coming up with anything off the top of my head. Mr.
Right.
Dyke, do you have any class of documents that you think would be particularly persuasive evidence as to he was in residence?
Well, utility bills are probably the most clear thing,
Okay.
Heather.
Well, it sounds like you're going to get those, so we'll do that,
I want to see the university sheet.
and hopefully that production will go off without too big a hedge.
It would be nice if he could be compelled to simply state when he resided there, but that might require deposition, or maybe who knows how complicated it can be simply to have the plaintiff state his time of residence.
And that is a different process than a discovery request, as you've noted. So let's see, that moves me on to defendant's motion to dismiss claim 4 for failure to state ultimate facts to constitute a claim. There's not a fourth claim for relief in the complaint. I think it was only mentioned in a declaration submitted, I think, in support of the motion for summary judgment. My note's not clear. And I know we discussed that at the time of that hearing, that was simply an error in including it. So there's not a fourth claim to dismiss. So I don't think I have any option but to deny that motion.
Your Honor, I'd like to say something.
Go ahead.
You're incorrect. That was mentioned in 3 different documents that they filed.
And, Your Honor, may I be heard?
Please.
As we indicated in our response to this motion, we did clarify with Mr. Dyke on June 5th that we don't have a fourth claim and that we're not seeking anything.
Your Honor, I don't trust anything she tells me, so until the court rules on a matter, I don't believe it's of any permanent benefit.
Well, I'm looking at the amended complaint, which at this point is the law of the case, so to speak, and there's only 3 claims for relief. There's not a fourth, so there's nothing for me to dismiss.
Well, Your Honor, we'd like to move the court to impose a penalty or something on the plaintiff and his attorneys for 3 times erroneously confusing this case with mention of a fourth claim.
Mr. Dyke, I'm not sure you want to make a request for sanctions when you filed a motion which is clearly meritless and you had previously been advised by the opposing party that the mention of the fourth claim for relief was an error.
That wasn't formal, though.
Motion after you were notified that it was in error, and additionally, the complaint clearly doesn't have a fourth claim for relief. I'm not sure you want to make a request for sanctions.
It was just mentioned more than once, Your Honor. It wasn't, as they would say, a typo. She told me it's a typo, and that's not true. It was not a misspelling. It's a properly spelled phrase, and it's mentioned several times. So she told me in an email it was a typo.
Mr. Dyke, whether it was a typo or an error, or however we wish to define typo, we discussed it at the motion for summary judgment that there was not a fourth claim and that it was an error in open court.
I've been trying to get that recording, and I haven't had an opportunity to review it because the file format is so complex.
Okay. Well, in any event, I know we discussed it. I know it was mentioned that it was an unintentional error. I guess most errors are unintentional. That it was an error, and we're going to leave it at that. I'm going to deny that motion, which I think clears all of the current motions. What I wanted to do today was discuss, beyond dealing with motions, was discuss with you folks whether or not you thought a judicial settlement conference might be helpful, or whether we should just be talking about finding trial dates. Ms. Ostrom, any thoughts?
Your Honor, we working with an additional law firm for adjudication of claims 2 and 3, so I would need to consult with them first.
Okay. Do you have an anticipated timeline when you could let us know whether or not a judicial settlement conference is something we could deal with, or whether we just need to schedule for trial?
I think I could let all parties know within the next week.
Okay. Mr. Dyke, you may not be aware of what a judicial settlement conference is, so I'll just give you a real brief description. It's essentially a mediation, but it's led by a judge. That judge is acting more as a mediator than a judge, and by that I mean, at the end of the day, the judge doesn't get to make a decision and say, this is how the case is going to be resolved. The judge's role is to help the two sides try and reach a mutually acceptable resolution of the case. And if that happens, then typically the parties would put that agreement on the record, deal with ultimately dismissing the matter, and it would be resolved. But at the end of the day, if either of the parties don't agree to resolve it, it doesn't get resolved and we would move on towards trial. Is that something you think you might be interested in pursuing? Or
I thought previously we were going to have something like that, but it never came about, and I didn't have time to figure out how to motion for it.
So is it something you'd be willing to participate and think might be...
Is there any expense in it?
There is, and I can't recall the fee off the top of my head. It is something that could be waived if appropriate. I'm trying to look up the fee while I've got you on the line so you know what it is. I want to say it's a couple $100 in a civil case, but I could be wrong.
The state has no funds for that much.
So it sounds like it's $210 until October 1st, and then it goes up to $223. And as I said, Mr. Dyke, it's possible that if you qualify, that fee could be waived.
Well, we're going to have to think about this.
All right, so here's what I'll ask you both to do.
Your Honor, we didn't have an opportunity to tell you what we were looking to plan.
And what's that, Mr. Dyke?
Well, we would like to complete our discovery and then move on with depositions, and then, if needed, move on with trial. We know that you can't do, I'm sorry, not trial, but summary judgment of our own. And we know there's a limitation. You can't do the summary judgment within 60 days of a trial. So
have you folks talked about setting depositions?
I'd like to complete my discovery first so I can have those documents in place.
Given...
Your Honor, we have
go ahead.
made no indication. We have made no request for deposition, nor have we received anything from the defendant.
We're not really planning to do that until our discovery work is done.
Given the rulings today, Mr. Dyke, do you anticipate making any additional requests for discovery?
Well, I guess maybe I need to clarify my one discovery request. Maybe that's evidence of actual possession. I'm going to have to think on that and see if I need to redo that one. Maybe utility bills would take care of that.
Okay.
I have to review my...
Request for utility bills, so we are working on that.
Okay. So here's what I think I'm going to do, because I don't want this to drag on any longer than we need to.
We shouldn't do it.
If I set another status conference for October 15th at 8:30, does that work for everyone?
No, Your Honor, we're out of town and we won't be answering email possibly or phone calls from the 13th through like the 22nd.
Okay, so you're out for a couple of weeks or a week anyway. Let me see what else I've got that would fit in that breakdown. I could do one October 24th at 8. Would that work?
They confirm, Your Honor.
Sure.
I will be out of town then. I will be out of town from the 23rd to the 25th.
Okay. Well, we're getting further out than I'd hoped. Let's see. Oh, go ahead.
I was just going to say, I would be available before Mr. Dyke goes out of town, but I don't know if that's too soon for you.
Well, here's my intention. I'm hoping that you've got at least utility bills and other documents that you think might directly relate to Mr. Byers being in residence or not, if those documents don't exist, to Mr. Dyke, so that we've resolved at least what looks like the currently pending discovery request, so that you folks can hopefully be talking about depositions if that's in fact going to happen. And so that then we can figure out what we're looking at in terms of potentially a settlement conference or Mr. filing his motions for summary judgment if that's what he wants to do after receiving the discovery. So I want to make sure we've got enough time between today and when we talk next that that's all been at least somewhat addressed so we can make some real progress. Does October 31st at 8:30 work? Halloween, if that's significant to anybody.
I like to celebrate Halloween, but I will definitely be available for a conference.
Mr. Dyke, does that one work for you?
We regarded it as a pagan holiday, but that would work for us.
I assume that it doesn't interfere with your schedule? Okay. So we'll set for October 31st at 8:30. And again, my hope is that we've gotten those utility bills and some indication if Mr. Byers was not in residence during 2018, so there aren't any documents that relate to actual residency on the property, that Mr. Dyke's been informed of that. That if you folks are going to do depositions, that you've at least attempted to schedule them by that date. Lay out our runway going forward.
Your Honor, I have a couple more comments.
Go ahead.
One, I have a backlog, a motion to compel for discovery requests that we already conferred on that I need to attend to. So there's any number of there's discovery requests that haven't made it to motion to compel, some that have made it to motion to compel that I haven't filed yet. In addition to that, there have been no rental records forthcoming. I thought we agreed along the way that rental receipts and records were discoverable, but a plaintiff's attorney is claiming there are no rental records showing rent paid.
Your Honor, can I respond?
Please.
We've provided the lease, and as indicated, have been told that there are no rental records, so we have provided everything requested there. Additionally, we cannot be expected to respond to motions to compel that have not yet been filed.
Of course.
And I don't think Mr. Dyke is asking you to do so, at least I'm hoping not, because I certainly can't address them if they haven't been filed. Mr. Dyke, it sounds like at least with the one they have responded that there simply aren't any documents. Now, again, if you don't like that response, I'm not sure there's much we can do about it if they say they don't exist.
Your Honor, this man has an accountant and a bookkeeper. All you have to do is ask the accountant how they handle the rental income. The plaintiff's attorney herself, previous attorney, mentioned the significance of rental payments. So that was what prompted the request to begin with.
Okay. Well, and again, if you've got some indication that response is...
It also would show the matter of possession, or confirm.
We can address that if you file the appropriate motion.
Your Honor, this was a part of my December of 2018 motion to compel, and it was brought up along the way and discussed. So, are you saying I need to redo that motion or that discovery request?
What was the date of that motion again?
It was one of my original discovery requests back in December of 2018. And there was 2 motions to compel, and there was discussion about it. Documents and things evidencing that the property was rented. And along the way,
Your Honor, we presented
Right, but along the way, it was requested under that discovery request, rental receipts, rental records. And it was addressed at some hearing, and there was an agreement to provide those or look for them or something.
And we've confirmed that there are no.
There we are on that one. If you have additional motions that you want to have filed, Mr. Dyke, please do that before that October 31st.
Motions? Your Honor, I won't have time to get all my outstanding discovery requests up to date and motions in place by then, because I'll be gone for a lot of October.
Okay. Well, what I'm asking you to do is try and have those filed by the 31st so that we can address them, so that we can move this matter towards a resolution. So that would be my request, and we'll talk to you folks all again on the 31st.
Thank you for your time.
Thank you.
Thank you, Your Honor.
Okay, that was very interesting.